All right. Hello, everybody. This is Lloyd Malik with another edition of Ask Lloyd. So October is Domestic Violence Awareness Month. And unfortunately, this is a problem that plagues every community across the country, rich, poor, black, white, wherever. There's always got to be some type of problems with between spouses and former lovers, etc. And I've invited to join me today a good friend of mine, Paul Griffin, who is also a lawyer. He works for the Child Justice Inc., which is a pro bono organization that represents people who cannot afford their own legal counsel in areas particularly regarding child abuse and domestic violence. And he's been at this for probably as long as I have, it seems like, for a long time, and is a person who would be a great guest, and I'm really happy to welcome you, Paul. Welcome to this edition of Ask Lloyd. How are you?
Thank you, Lloyd. Thank you for having me. I'm doing well. Thank you.
Yeah, so a lot of times when people come to, I guess, I'm assuming you, but they come to me and they have questions, they're potential clients, and they're concerned something isn't going right in their life, of course, but they may be having a problem with their spouse, and there may be some type of either abuse or violence committed. Typically, what's the first thing that you do when they come on in and you say, "Hey, I see you got a problem. How can I help you?" And how do you start off dealing with these types of issues?
Well, our cases in particular would involve there has to be a connection with children, even if it's our traditional case is a custody case involving domestic violence or child abuse, and we think that we also consider domestic violence almost a form of child abuse because it does expose a child to violence. We also will do protective orders, which is very often the initial step. So as you phrase it, when we get a case, if it's, let's say for sake of argument, it's a new development to this parent, it's the first time they've gone to court, they've come to us, depending on the evidence that they have, we would very seriously consider and recommend seeking a protective order to protect them from the abuse, to protect the child from exposure to the abuse. And that is something that we could file either in district or circuit court in any county in Maryland. And we would then make an appearance on their behalf at the initial, usually at the initial appearance, which is a temporary restraining order, which is a temporary protective order, which it can be ex parte. It could be the party standing up and telling the judge or the court or the magistrate what happened. And if they show the elements necessary for protective order, that there's a violence or threat of violence, the reasonable fear on behalf of the petitioner, then a temporary will be entered. It'll be served in person by deputies on the respondent, the alleged abuser, if you will. And then usually within 10 days or so, a week to 10 days, there will be a final hearing, which is a normal hearing where both parties are represented, both parties can have counsel, rules of evidence apply. You can call witnesses, put on evidence, etc., and we'll handle that as well. That will often then segue into our, often, but not always, segue into our taking on a custody action for a more long-term, permanent, if you will, to the extent custody orders are permanent, a more long-term, at least, remedy for what's going on. So we would then often file, if there's a current custody order, then we'd file a modification. If not, we'd file a motion for modification. If not, then we'd file a complaint for original custody order, first initial custody order, generally asking that our client be given custody because we believe a lot of the inherent flaws with a domestic abuser does not make them generally a good parent. So that is usually our typical case for us from 1,000 feet.
Right. So one of the things that that I've seen, which I find it troublesome, is sometimes what you have the abuser who is making the allegations. Those are situations that become very, very trying, at least from the practitioner, the lawyer's point of view. Have you also experienced those types of cases?
Oh, we have. We've had it multiple ways. We've had the abuser, the person that we believe ultimately after being in the case a while or doing some due diligence that we believe them to be the abuser, have them come to us as the victim. very common, as what you describe is very common. Abusers will deflect and blame and make counter accusations in order to gain the advantage in court, as though they are themselves the victim. And that does happen, and it can get very messy, get messy for the lawyers, get messy for the court to sort out. It's hard, and particularly if you want to segue it into child abuse, it's very hard to prove. There's very seldom, as particularly in child sexual abuse, there's very seldom as going to be physical evidence of it. So they are hard cases. We have to do our due diligence, and we are no better than your average person at discerning truth from somebody. I think lawyers think very highly of their skills, and judges do as well, as discerning truth. But studies have shown by tests on lawyers and judges that we're no better than lay people, and it's basically a coin flip. So that's why you have to look at what evidence you have. And often it's very little, but you look at what evidence you have, and then you try to discern patterns. Also, if this is ongoing systemic abuse, there's usually other telltale signs. There's usually economic abuse, controlling abuse. You might talk to family members who say, we were cut off from her a year ago or 2 years ago and barely talk, or whenever she came over, he had to be with her. Just things that might show indications that support the idea there's abuse. But to get to your central point, Lloyd, it's difficult. I'm not, we can't kid ourselves. It can be difficult sometimes in these cases to discern what has gone on.
Well, it would be ideal if all of my clients all the time are always in the right. I really hope that I really hope that they that they are being forthright, and we are able to help out the people who really, really need our help.
Sure.
So anyway, with respect to some of these remedies, say we have now, we're going down the line a little bit. Courts have made some rulings. There's some orders, and one side, well, I guess it would be the other side. Let's take it that way. The other side who has an order to, well, let's say there's a custody order or an access order or a support order or some type of order that the other side is required to do something, and they're not doing it. So now you have a court order, you have a spouse or partner or former spouse or partner on the other side not obeying. What do we do? What do we lawyers do when these things come up?
Well, that's a great question. Usually the most common vehicle is contempt, a contempt of court, what's called constructive civil contempt. What constructive civil contempt is, it's not like in TV where someone stands up and yells at the judge, and the judge drops the gavel and says, "You're in contempt, mister, I fine you $50. Constructive civil contempt is something that happens outside of the observations of the court. So it's as you described. The judge says, go do X, and the person doesn't do X. And it's civil because it's civil in the sense it's not criminal. That the court, and I'll get more detail into this. The court in a constructive civil context is trying to coerce compliance with the order, whereas in a criminal context would be certainly a past completed event that the person did that's in violation of the order that the court's now trying to punish them for. That it's very rare. It does happen, but I've been doing these cases for 21 years. I don't think I've ever had a case ever go up on constructive criminal contempt because of the prosecutors have to be involved. And I don't want to digress too long on this, but it's like any other criminal case. You give a jury trial, they have a right to remain silent. They don't have to testify, rather, and they have has to be proved beyond a reasonable doubt. So it's a very lengthy process. So normally you're not going to see that. You're going to see constructive civil. And we deal with that a lot. That's actually one of our most common issues that we take up. And by coincidence, we just filed a brief in the Court of Special Appeals last night. We have 3 current appeals outstanding in front of the Court of Special Appeals that we'll be arguing having oral argument in the next 5 weeks. Wow. We don't usually have that many going on at once. That's an extraordinary circumstance, and it's just a coincidence they all popped up around the same time. But I could talk a little about the contempt issue, a little more if you like.
Yeah, well, before we do, just with respect to some of these contempt issues, I want to just mention to you, because I think this is really interesting. A client of mine actually is being criminally tried
really?
in Georges County for not abiding by the consent order for custody. She decided that, well, this is not really in the child's best interest, and there is an issue. So they are prosecuting her, and they're not calling contempt, but there's this statute. I'm not going to cite the statute number right now, but there's a statute that actually, it would be a violation if you don't comply. So, I mean, I rarely ever see it, and
Yeah.
I'm gonna get thrown out, but you know, for various reasons, I'm pretty sure I'm gonna get thrown out. Nevertheless, you know, I've not seen this very often, but it
No,
does.
you don't. You don't. You'll see occasionally a kidnapping, or what they call it, the kidnapping statute. I mean, it's not kidnapping, and it's legally kidnapping. I'm not minimizing. It's not kidnapping in the sense we're thinking of. You know, so no one came in the middle of the night and stole the child, but a parent will abscond with the child and not make the whereabouts known, which is kidnapping, and it's wrong. And we absolutely do not condone that. You'll see those charges occasionally, but like I said, I haven't seen a criminal contempt one. So what you're describing is a first.
Mhm, mhm. Yeah. So you're saying you had several cases going up on the Court of Appeals on the contempt issue. So let me ask you. So we were talking about the contempt. Yeah, you file for contempt. What are the remedies? What does the court do when they find that there has been a violation under constructive civil contempt?
All right, you raise a great question, and what we're doing right now is two of our cases are for what we call past completed events, and I'll come back to that in a second. And the other one, the issue is well, there was procedural issues. The client wasn't read her rights, which she's supposed to be because she's pro se. But more important, what we see more often is that it's a vague order. The order does not require specific performance of an act, and the court will interpret it such that she didn't comply with something that was not ordered. This is not what happened in this case, but a great example of that would be a monetary issue. If the court says pay 50% of tuition, that's a more popular, common issue, and one party does not pay. Often the other party will go and seek a contempt order. The court will then hold the person in contempt and say, you need to pay this money, or I'll put you in jail, or I'll fine you, X dollars per day until you pay. And really, under the case law out there, they're not really allowed to do that. Unless it's a specific amount, the order has to say pay $512. So we're actually on both sides of this issue right now. We're about to file a motion with the court. What you need to do when you have an order that says pay X% or something vague like that, you need to get a specific amount where they are in arrears. So they haven't paid $5,212 for tuition, let's say. You need to go to the court and say, we want an order saying this person needs to pay $5,212 that is owed, and have 15 days or however number of days the court wants to give them to pay it. You can get that done. Often the person will then comply, but if they don't, they can then be held in contempt of that subsequent order, not the 50% order.
Yeah, is that raised by affidavit attached to a pleading, for example?
Yes, exactly. It would be a sworn, they have a sworn pleading, absolutely verified pleading. Yeah, but the most common thing we see is that you described when there's been a violation. I'll use a custody as an example, because that's what we deal with a lot.
Mhm.
Parent is ordered to produce the child every other weekend or what have you, and doesn't produce the child. Or Christmas Day, child's supposed to go to dad's house, let's say. And for whatever reason, mom doesn't give the child to dad. Now, for sake of this discussion, let's say mom had no good reason, right? Let's say mom was being malicious, for just the sake of this discussion, because there's other defenses that get into play if you had an acceptable excuse for it. But in this case, there was no, or at least the court found no good reason, let's say that. But subsequent to that, the following weekend when dad had him for New Year's, dad got the kid, and dad's had it for the kid every other weekend or whatever the visitation order requires. Because usually by the time you get in front of court, we've had them come up 5-6 months later after
Of course, right.
court hearing. You're not going to get a court hearing tomorrow. So by that time, the party is in compliance. We're looking at a past event. And our position on the two of the briefs that we have, and we've won on this issue before, but have never gotten a published opinion. Now we're seeking it this time. And we think that the logic of the case law is such that you cannot be held in constructive civil contempt for a past completed event. If the person is in compliance with an order while they're standing in front of that judge, they cannot be held in constructive contempt for a past event. The court can, of course, refer for criminal contempt, which is not realistic, but the court has other remedies. And I won't get too long on it, but Family Law Article 9-105 is one of them, which really is what the contempt article is. They're trying to do through contempt is try to get a makeup time, attorney's fees, any other orders the court wishes to issue that would help compliance with the order. But but strictly in contempt, we take the position, and we think it's the correct one, and we hope the court will agree with us on this, that a past completed event cannot be for constructive civil contempt because there's nothing to coerce.
However, if the whole point was to prevent this from happening again, right, you said changing the order, giving makeup time, would that be a ruling in contempt, or would that be some type of just modification? And if it were just modification, is that something that a judge can do on a contempt filing?
The answer to your question is no, it should not be brought through contempt. What you're asking for is remediation, and to be treated as remedial. And the court in the contempt case law does describe contempt as a remedial action, but then it describes it in another case. I have to look up, I'm sorry, I'll get to you in a minute. But that when they're talking about remedial, they are not talking about it like the way we think in a tort or contract, breach of contract case where you're getting someone whole again. They're not there to be made whole through contempt in that regard for past events. You have to also use other remedies. So to the extent you're trying to prohibit it going forward, only if they are currently in contempt can the court actually have, in our view, the jurisdiction to issue an order to do that. Again, Family Law Article 9-105, or just the court's inherent powers. I mean, the court has broad inherent powers. Can fasten orders to not only give the makeup, but to remediate, if you will, but to facilitate making it easier going forward for compliance, whatever that might be, changing the drop-off place, making it so dad can pick the kid up from school instead of relying on mom, or what have you. It's a jurisdictional issue, really. We think the court does not have jurisdiction if there's not an ongoing active contempt in front of them. And I also might add that contempt, this is the Kowalczyk case, which is a published opinion we did get. I'll give you that spelling in a minute, but it holds basically that you can't use contempt. You can't use a contempt process for a change of custody, as a modification. Now, having said that, you can use the underlying acts as a basis for modification.
So essentially, Paul, you're saying just file two motions in that case. File the contempt and then file the accompanying modification.
Exactly. And you can make the argument, and there's case law out there. Usually in other states, there is one case law, Berlin versus Berlin in Maryland, that basically says that it goes to character, if you will, that the person who will not comply with an order, it's a knock against their character, which can be sufficient to find a change of circumstance to modify the order.
Sure. I mean, we hear all this all the time when a judge is trying to even issue custody. They'll look at all these other things like, well,
exactly.
Well, you didn't give visitation when you had the opportunity to. You're hurting the kids. You don't realize it. And these are all factors.
Correct.
So anyway, there's a lot going on here. I am very excited that I got a chance to talk to you about this stuff. This is, it's amazing how what we do overlaps so much, and there's so much that we could really do to help our clients. And if there's any people who come on down, you can look for a consultation over here with me who can't afford this and are eligible, I'd be very, very happy to let them know about Child Justice Incorporated and your great work that you guys are doing over there. So I want to thank you for coming on to Ask Lloyd, and appreciate it very much.
All right. Thank you for having me. Good seeing you again.
Thanks so much.
Thank you. Bye-bye.
All right.